Are you a retiree or a pre-retiree with more than one property? One property is considered a principal residence that you consider your home, and you have another property is a vacation property, investment property, and you want to transfer the property to your child. Well, this video is going to be very helpful to you. Let's get going. Now, to make things simpler, as opposed to just talking in abstract terms, I've created a bit of a case study here, so let's walk through it. So let's say we have this individual, let's call her Susan. Susan has a vacation property. It's worth $2 million. Now she purchased this 25 years ago for $250,000. She's made capital improvements to the property to the tune of $450,000, right? So again, the fair market value, $2 million. Between how much she paid and improvements, the adjusted cost basis is now $700,000. And so 2 million minus 700,000 means there's an unrealized gain of $1.3 million. Now, Susan also has a home, and she designated that home as her principal residence. Why is that important? That's important because if you have a principal residence and you have a deemed disposition, you pay zero in taxes for that, right? So because she has a home that's principal residence, then we know that the cottage cannot be afforded a property because only one property can be given the privilege of being called the principal residence. Now, Susan has a daughter called Janet, and Susan wants to avoid probate fees and want to continue using the property as she pleases. So what does she do? She transfers this property to Janet. She says, Janet, you know what? I don't want to pay probate. I know you're going to get this property eventually anyway, but I don't want to pay probate. And in addition to not want to pay probate, I just want you to promise me that I'll continue, to be able to use this property. Janet says, sure, fine. She makes the transfer. Here are the ramifications of that transfer, which Susan was not aware of. It's a deemed disposition, and as we said, it's an unrealized gain of $1.3 million. So she must report 750% of taxable income, right? Because it's a capital property, and so there's a capital gains, and there's a 50% of 50% inclusion rate on the gain, and so she must report $750,000 off the 1.3. Now, if you have once we've established what that gain is, we have to multiply that amount by the 50% marginal tax rate. And we're going to assume that the marginal tax rate is 50% for example purposes, make sure it works. So we're going to assume that the marginal tax rate is 50%, which means Susan has to pay $375,000, right? So let's walk that through one more time. Unrealized gain $1.3 million, 50% inclusion rate brings it to $750,000. We're going to times that by the marginal tax rate, which we're going to assume is 50%. So now Susan has to pay $375,000. But she said, hey, I'm giving this as a gift. There shouldn't be any problems. However, she learns after that that's not the case, and the CRA steps in and says, Susan, you owe us $375,000. In addition to the $375, you will have to pay interest and penalties. So, it's a little bit more than Susan had been bargaining for, but things take a turn for worse. Because then Janet gets a divorce, and Janet was married to John, and John claims cottage as part of the family property, and the fair market value of the property, as you said, was $2 million, and Janet cannot afford to pay him the $1 million because, he's supposed to get half. So we're going to assume that the court said, it's considered a matrimonial home, and so therefore he should get 50%. Well, what happens here? Susan wants to retain the use of the cottage, so guess what? She has to pay John $1 million because she has all her memories attached to this space. This is where her grandkids are. This is, she sees her grandkids there. She has her kids. She raised her kids there. In the past, she had friends that have gone there. There's so many memories attached to it. She may not go there a lot throughout the year, but when she does go, it's a special place, right? So now it's cost her the $375,000, right, from the disposition, and now the $1 million to keep it from John. So all of this, as we can see, has been costly. By Susan transferring the cottage to Janet, it has been truly a costly decision. So let's look at some alternatives. Well, Susan could have distributed the cottage as part of the estate. And I know the concern was about probate taxes. And if there's concern there about paying the taxes, well, especially Janet, because she's a beneficiary of this, then if Janet was so concerned also, what she could do is she could have paid for a life insurance policy on Susan's life that covers the taxes. And I guarantee, depending on the health and if she qualifies and everything else, it may have been substantially cheaper than the $1.3 million. And after all, Susan's going to be getting this cottage worth $2 million, right? So huge benefit there. Now, if Susan insists on avoiding probate if she's over 65, she may hold the asset in an alter ego trust. I won't speak too much on that. I'll leave that to, your lawyer and financial experts. We're not going to delve there. But just know this is an alternative, the life insurance aspect of it, or potentially an alter ego trust. So for those out there with second properties, do not think that you could just gift this property and not report it and things go smoothly, because, you potentially will be looking at, one, the taxes, interest, and penalties after CRA finds out. In addition to that, this property is now owned by your child and it's subject to being part of a family law case where potentially they could lose the cottage, and which ultimately means you could also lose the right and access to the cottage. Again, this is just, one alternative. Hopefully this was helpful. If you have any questions, drop it in the chat. Drop it below in the comment section. Like, share, subscribe. If this benefit you or you know someone who this could benefit, then go ahead and share this, and I will speak with you soon. Take care.